Today, I will explore a topic that touches the financial heart of many Arkansas families: whether to title assets in the name of their children. Whether driven by worries about probate, a desire for tax efficiency, or a wish to help children manage resources, this decision brings real legal, tax, and family consequences. So I'll break down why parents consider these transfers, the common forms used in Arkansas for these transfers, and the fundamental benefits and risk involved with these types of transfers. My name is Leon Jones Jr., and for over 15 years, I've practiced in courts in both state and federal in Arkansas. I've also worked for a Fortune 500 company, and I've held the positions of the director of the Arkansas Department of Labor and the executive director of the Arkansas Fair Housing Commission. Now, I'm the managing attorney here at Big Rock Legacy Law Group, where we advise and represent clients in business law, civil litigation, estate planning, and family law. Over these many years, I've had families deal with this very issue, and I hope to provide some insight into how I provide advice, which is different for every family. Now, parents in Arkansas frequently think about titling assets in their children's name, and they do this for a number of reasons. Number one reason is to avoid probate, making asset transfers quicker and possibly less expensive at death. Number two, it simplifies the estate planning process. It does so by putting property directly under the child's control. Thus, it reduces the need for court oversight. Number three, parents do this to take advantage of federal, state, and gift tax exemptions, using annual exclusions and lifetime exemptions to help minimize their tax burden. Number four, it helps to shift income. They hope that investment returns will be taxed at a lower rate through their children. Number five, to plan for Medicaid and long-term care by moving resources out of their own name before applying for this assistance. Number six, to support education through accounts like 529 plans and custodial funds. And number seven, it helps lower the risk by moving business assets and other potentially litigious assets outside of the parents' direct ownership. Now, in Arkansas, parents use a variety of instruments in order to accomplish these goals. One of those is the outright gift, transferring ownership of bank accounts, securities, or real estate to a child directly. Next, payable on death, POD, or transfer on death, TOD designations. Arkansas law allows for these designations as well as beneficiary deeds for real property and those bank designations and brokerage accounts to take effect at the death of the person, thus bypassing probate. There's joint tenancy with the right of survivorship. This means that parents can add children as co-owners, but keep in mind, the child does gain immediate rights to those property. And custodial transfers under what is called the Arkansas Uniform Transfer to Minors Act. Now, these assets are managed by a custodian until the child reaches the age of majority, which is about 21, maybe 18 in some situations. And of course, trusts, which can hold assets for children, balancing potential parental control and eventual transfer, while offering some additional planning benefits. So let's get started with your planning today. Click the link below, book your no obligation strategy session, and let us help you. Now, one of the strongest arguments for these transfers is, of course, avoiding probate. The next would be outright gifts, joint rights with survivorship arrangements, TOD, POD, and beneficiary deeds. They all help to remove assets from someone's estate, thus avoiding the probate process. More importantly, Arkansas beneficiary deeds are revocable and they preserve the parental control while enabling a quick post-death transfer. Now, when you gift assets, especially using the Uniform Transfer to Minors Act accounts, it can keep future appreciation out of the parent's taxable estate. Now, there are annual exclusion rules up to $18,000 per year, and they often come without reporting requirements. Larger gifts use lifetime gifts or estate exemptions. Assets that generally change ownership can shift income to the child's tax rate if it's lower, but beware. The federal kiddie tax may use unearned investment income to be taxed at the parent's rate once it crosses the threshold amounts. Now, these custodial accounts and 529 plans are effective to set aside resources specifically for a child's education, but they carry fiduciary duties for custodians, and they also give clarity of ownership. When you change title and add beneficiaries, it's typically less expensive than creating complex trusts and estate plans. However, when it's that simple, sometimes the risk, as they say, the details, the devil is in the details. Now, these are risks, and there's some drawbacks, and there's some Arkansas-specific issues that we need to address. When it comes to outright gifts and joint rights or survivorship arrangements, turning over control, the parent cannot revoke these gifts. The parent can't dictate its use, nor can the parent restrict the child's ability to sell or encumber the asset. The parent's rights regarding property sales, refinancing, or transfers are often limited by the child's co-ownership. Also keep in mind, assets titled to a child are open to those claims by that child's creditors. If the child goes through a divorce or bankruptcy, it could put the family's assets at risk. During the parent's lifetime, using TOD, POD designations, and beneficiary deeds helps to avoid some of this exposure. Outright gifts can generally carry over a parent's basis, often leading to higher capital gains taxes when a child sells the property, which will diminish the child's inheritance. Now, although Arkansas law does not have a separate gift or estate tax, federal rules will still apply. Even casual, innocent transfers can inadvertently terminate planning opportunities. For example, minors' unearned income above a certain level is subject to the kiddie tax, thus reducing the benefit of income shifting without transferring genuine control. Arkansas law does follow a federal 60-month look back for asset transfers, meaning gifts within this window can trigger a penalty period, delaying Medicaid eligibility, and it could remove resources potentially needed for care. So last-minute and uncoordinated transfers often invite challenges. Adding one child as a joint owner commonly leaves that child with the entire asset by survivorship, often causing unintended disinheritance or intra-family litigation. Now, when we talk about custodians managing those minor accounts, they must follow strict legal standards. Any misuse can lead to liability and conflict. Upon reaching termination age, the child does become the absolute owner of that account, and those transfers can trigger lender clauses, which may require the need for a new title insurance, and it could complicate property tax and homestead treatment. Again, Arkansas's beneficiary deeds are revocable, but they require proper execution. Transfers that attempt to defeat a spouse's rights can be challenged in court. So therefore, careful structuring is essential to keep your estate planning sound. When you use TODs, PODs, and beneficiary deeds, or even if you use trusts, these can offer smoother alternatives. Please don't forget to click below to schedule a call and let us get started today. Now, remember, when you make the right choice, you have to consider a few things. One, your specific objectives, whether probate avoidance, tax efficiency, creditor protection, control, fairness, and long-term planning are essential. The type of asset, whether it's a real estate asset, business interest, cash, or retirement account. You also have to consider your timeline and your health, Medicaid look back, anticipated care needs, and your life expectancy. You must consider the tax exposure, asset bases, gains, got to consider family dynamics, the trustworthiness of children, and you also have to consider keeping wills, trusts, and beneficiary designations harmonized. But it's not a one-size-fits-all solution. Let us help you ensure that all the pieces of your plan fit together before making lifelong property decisions. Make sure you subscribe to our channel to learn more about how we help our clients every day here at Big Rock Legacy Law Group.